fights with passion, and he inspires.
Are you ready for a war?
All right, welcome back to From 8 Arbitration, the Monday edition. Yesterday had the Wolf on, and that's kind of going to be the format between now and election. Sundays I'm going to have members of the CLC slate on. This next Sunday I'm going to have the 3 Table 2 carriers that are on the slate. They want to talk to you. Then we'll have business agents, resident officers, and things like that. That'll happen up until the election. And so on Mondays, solely education. Back to, the roots of where we started on From 8 Arbitration. And so we're just going to have education solely on Mondays. Got a long episode today, a lot of reading, but you'll need a pen and paper. Got some good stuff for you next Monday. Already booked with stuff for next Monday. All right, and so that's how we're going to do it. Only From 8 Arbitration Facebook pages. No more politics. Going back to education only on those, okay? If you want to politic, do it on yours page. Wherever your supportings page, there'll be no CLC, no anybody else on the From 8 Arbitration Facebook pages. So somebody not like that, don't care. Getting back to education, what people started listening to From 8 Arbitration for. And Discord and Reddit, of course I don't have any control over Reddit, but Discord I think kind of going to be the same thing. But so if you want to do politics, From 8 Arbitration, the Facebook pages will no longer be an avenue for you. All right. Like I said, if whoever you're running for has a page, do it on that, or do it on your page or whoever else's page. But we're going to get back to educating on From 8 Arbitration. That's my passion. When James and I take over, that's going to be priority one, is education. It's his passion. It's my passion. And that's what's going to happen. That's one of the things that he's talked about, education. And so we will have education out the yazoo when we take over. That's the reason he's bringing Paul Bolanger in as the Director of Education. So, yes, education. That's where it's at. I want a lot of grievances filed. I'm not one of those that says we file too many. I don't think we file enough. I think we need to educate our members, protect the contract, and file grievances, and that's going to be my MO. So, yes, that's going to happen. Some trips we got coming up tomorrow, LA, Branch 1100. We'll be there, all right? And so make sure y'all come out and see us. Wednesday, Branch 214, Sacramento. Make sure y'all come out. Saturday, Branch 3877, a meet and greet. That's in Richland, Washington. And then Sunday, Everett, Washington, Branch 791. That's the 16th. Make sure y'all come out. And so there you have it. Going to get straight to it. I got a lot of things. One's going to take a long time, and it's a lot of reading. But as far as our women are concerned, we were always going to protect our women, okay, on the workroom floor. At no time ever is it okay to address or attack our females. All right, guys? And so we're going to protect our women. And I've got something, I will end with that one. And I've got a podcast that's come out. And you're going to want to listen to it. I told you I wanted my assistant steward, extremely educated. She is an incredibly religious woman. I wanted her to start a religious podcast. Hadn't talked her into it yet. but I've got one. A gentleman that's a good friend of mine. He started this podcast, and it's a religious one, and it's dealing with addiction. And so I think that this is something that you will really like. He sent me an episode. It's fantastic. And so if you can find it, About Cross and Canvas. About Cross and Canvas. And I'm just going to read you. I told him, I said, send me a little synopsis of it. If you're looking for a podcast that's equal parts thoughtful, funny, and authentic, check out Cross and Canvas, hosted by Andrew, a sobered tattoo mail carrier, and Danielle, an Episcopalian priest. The show explores faith, life, and the everyday moments where the ordinary and the divine just might collide. They tackle real questions with humor, honesty, and zero pretense, proving that meaningful conversations don't have to take themselves too seriously. Whether you're a lifelong believer, spiritually curious, or just enjoy good conversation, Cross and Canvas is a podcast worth adding to your playlist. Just remember to ask for yourself, is it odd or is it God? And so I love that, but Cross and Canvas. And I told him, absolutely send that to me, brother, and I'll put that out there. And that's fantastic. You can't have enough educational podcasts, and this is one that's dealing with addiction and different topics. But yeah, there you go. Cross and Canvas. Y'all check that out. Here's something that somebody sent me, and these things always piss me off, and they will forever piss me off. And it has kind of fueled my hatred for management. And this is something that when we get in, we will address nationally through a national level grievance. That's going to happen. And until then, you've got to grieve these messages. And listen to this message that was sent out over the scanner. And somebody sent me this today and said it pissed them off, and it pissed me off when I read it. And so this is the scanner message. Carriers, you need to be mindful that this place is under a microscope for a variety of reasons. One is because of your street time. With that being said, carriers having 2 minutes of inactivity does not help your calls. You guys need to stop milking the cow and give an honest day's work for an honest day's pay. Again, you're being watched. I'm going to read that again. Carriers, you need to be mindful that this place is under a microscope for a variety of reasons, and one is because of your street time. With that being said, carriers having 2 minutes, that's what it looks like to me, 2 minutes, 2.17 minutes of inactivity does not help your calls. You guys need to stop milking the cow and give an honest day's work for an honest day's pay. Again, you are being watched. To me, that is a clear violation of Section 134 of the M39 Handbook. We should have addressed this long ago. As soon as the metrics came out, should have been addressed nationally. Inquired about what they're going to do, what the process is, nationally file the grievance. It's a violation of 134 of the M39 Handbook. Management has nothing in any handbook or manual that tells them that they can do this. We do have something in a handbook or manual that says they can't. And that's exactly the argument you're going to make to whatever national arbitrator you go in front of. I'm also going to file a Section 115.4 of the M39 Handbook. You're not going to threaten me or accuse me over the scanner. And I'm going to get as many statements as I can. You got the screenshot right here. And you're failing to maintain an atmosphere of mutual respect when you do that. That's all that is. I'm going to read it again. Carriers, you need to be mindful that this place is under a microscope for a variety of reasons. And one is because of your street time. Now, what is my street time? I have no street standard. Isn't that what 1769 says? M1769? Right? There's no set pace at which I must walk, no set pace for walking. I have no demonstrated performance, right? And so, with that being said, carriers, having 2 minutes of inactivity, and that goes along with keep it moving, beat the heat. You cannot stop for any reason, period. You have to continuously be moving. You can never stop. You can't arrange your mail for 2 minutes. You can't do it. You have to continuously be moving from the time you clock on to the time you clock off. You have to be moving. We're the only craft that has that put on them. Nobody else has that kind of expectation put on them, right? Nobody else. And so I'm going to grieve that. You can put in the contention. I wouldn't put that in your issue statement. 1769. We have no street standard. There is no demonstrated performance. We take breaks as needed in the heat. Sometimes we have to shuffle things. We drop things. We drink things. You know, it happens. As a carrier myself for 34 years, things happen, right? I get out of my vehicle, drop my key. I'm not stationary. I'm working. I'm doing something. And so under Section 134 of the M39 Handbook, if you have such a problem where we're being watched, then according to 134 of the M39 Handbook, you must come out and observe me. You must accompany me on the street if you think I'm doing something wrong. They're not doing that. I'd request the 4584s. But I'm going to grieve that scanner message. Okay? Plain and simple. I'm going to grieve it. And so I've got a 16.7. I'm also going to read from this. And some people may not like this idea, but this is just me. This is how I'm going to handle these situations. And I've talked about this before, but somebody sent me this the other day, and I think it's the perfect example of what I'm talking about. Now, here's the 16.7. It's June 16th, 2026. Emergency placement in an off-duty status. For the reasons set forth below, you are hereby notified that you were placed in an off-duty without pay status effective June 13th, 2026, pending an Office of Inspector General OIG investigation. You will continue in this status until you are advised otherwise. A further decision shall be made as to whether or not discipline shall be issued to you for the alleged misconduct. That decision shall be forthcoming in the near future. My actions are in accordance with Article 16.7, Emergency Procedure of the National Agreement, wherein it specifically states an employee may be immediately placed on an off-duty status without pay by the employer but remain in the roles where the allegation involves intoxication, use of drugs or alcohol, pilferage, or failure to observe safety rules and regulations, or in cases where retaining the employee on duty may result in damage to U.S. Postal Service property, loss of mail or funds, or where the employee may be injurious to self or others. You may utilize accrued annual leave, if you have any, during this period of off-duty status. You have the right to file a grievance under the procedure set forth in Article 15 of the National Agreement within 14 days of your receipt of this letter. So I'm going to read this one part again. For the reasons set forth below, you are hereby notified that you are placed in an off-duty without pay status effective June 13th, 2026, pending an Office of Inspector General investigation. You will continue in this status until you are advised otherwise. A further decision shall be made as to whether or not discipline shall be issued to you for the alleged misconduct. That decision shall be forthcoming in the near future. Now listen to me. My actions are in accordance with Article 16.7, Emergency Procedure of the National Agreement, wherein it states specifically, an employee may be immediately placed on an off-duty status without pay by the employer, but remain on the rolls where the allegation involves intoxication, use of drugs or alcohol, pilferage, or failure to observe safety rules and regulations, or in cases where the retaining the employee on duty may result in damage to U.S. Postal Service property, loss of mail or funds, or where the employee may be injurious to self or others. Can you tell me what happened? When it happened? Where it happened? What time it happened? If you cannot answer who, what, when, where, and why, then this is procedurally defective. I have got to tell with some kind of specificity exactly what happened on June 13th. There's nothing in here. As an informal Step A representative, as the shop steward, when I get this, I'm not putting in an information request. I'm going to write a statement that management handed me this 16.7, or the carrier handed me this 16.7, and based on the 16.7, I cannot tell what happened on June 13th, whether it was in the office, on the street, what happened, who it happened to, where it happened, how it happened. Those things are not on this charged letter. I will not make contentions based off of something that I think happened or something that management told me happened. I'm going based off of the charged letter. In arbitration, when I'm sitting there as a witness and my advocate hands me this, or I'll turn to it in the case file, and they're going to say, what happened? I have no idea. Well, when did it happen? Sometime on June 13th, I think. It could have happened on June 12th or 11th or the 10th. I'm guessing it happened on June 13th. Was it in the office? No idea. Well, was it some kind of safety violation? No idea. Was this person intoxicated? Don't know. Well, did they pilferage the mail? No idea. Do not make the case for them in your contentions at the informal step A level. I'm going to write a brief statement. I received this notice. It doesn't tell me any specifics. It's impossible for me to defend whoever based on this charge letter. Now, management will say, well, you didn't put in an information request. I don't need to. It's not my burden to prove innocence. It's your burden to prove guilt. This is still discipline, correct? Article 16.7, it's either you're going to have a contractual or a disciplinary 16.7. If it's me having an adverse effect on medication, that burden's probably going to be on us. If it's discipline related, it's going to be on them, and they will carry that burden all the way through arbitration. And so I would let the formal A, if they want to come in at the formal step A level and say, here's all the specifics, I'm going to say, I appreciate it. I will address those, but in arbitration, I'm going to hand the arbitrator this notice. In my closing, and I've done it before, I've had closing arguments on my podcast before, I'm going to hand him this notice or her this notice. And I'm going to say, can you tell me what happened? If you can't tell me what happened, I can't tell me what happened. They can't tell me what happened. This is the charge letter, no different than the charge in court, right? We've talked about that before. Do not make the argument for them. It's alleged, I was talking with the supervisor, it's alleged that this happened. I'm not doing that. That's their job. That's their job. I'm not going to speculate, right? We're not going to do that. I've got two sites for you. Both by Arbitrator Roberts, both are cases that I did. And I did the same thing with him. I just handed him the damn notice and asked him, can you tell me what happened? If you can't, then you have to sustain the grievance. You can't deny it. And so one is C30557. 30557, and this is way back in 2012. And this is what he states. It's on page 8 of 12. Conversely, Article 16.7 requires a less stringent gauge, something less than the preponderance of evidence. Nonetheless, the employer is required to show their emergency placement decision, made on the facts of the case available at the time of their decision, was reasonable. And in this case, my findings are based solely on the facts and circumstances available to the employer at the specific time of the emergency placement. And with that in mind, each emergency placement rests on its own set of facts and circumstances. Since this case does involve discipline, the employer retains the burden to show just cause for the emergency placement. However, given the language of Article 16.7, the requirements in meeting that burden of proof are lessened somewhat based on the facts and circumstances surrounding each individual case. Goes on to page 9. However, controlling in this matter is a 1990 national award authored by arbitrator Richard Mittenthal, case number there. I would like to point out that I'm very familiar with this award regarding emergency placement. I've utilized arbitrator Mittenthal's reasoning in many of my prior decisions regarding this very same subject matter. In pertinent part, as it applies to the instant case, that national award provides, this is the language, the fact that no advance written notice is required does not mean that management has no notice obligation whatever. The employee suspended pursuant to Section 7 has the right to grieve his suspension. He cannot effectively grieve unless he is formally made aware of the charges against him. The reason why management has invoked Section 7. And that is the most important language of arbitrator Mittenthal's award. He cannot effectively grieve unless he is formally made aware of the charge against him. That's important. Why? Because it shows you that the charge must tell me what I did. Right? The reason why management has invoked Section 7, you can't put all of Section 16.7 in there and say, I violated all of these. You have to tell me with some kind of specificity what I did when I did it. I've got to prove that it was immediate. How can I prove that it was immediate if you tell me that on one date I was put on emergency placement? I don't know if that was immediate. I don't know what to request. You didn't tell me what happened. He surely is entitled to such notice within a reasonable period of time following the date of his displacement. To deny him such notice is to deny him his right under the grievance procedure to mount a credible challenge against management's action. The Joint Contract Administration Manual also reiterates similar language. The key point in all of this is the fact that the grievant and or the union would be totally hindered without a formal written charge being presented, albeit in this case, the emergency placement letter. Specifically to the case, the letter mentions only an alleged violation of safety rules. We don't even have that. The document lacked any detail as to what specific safety rules were violated and failed to define any acts that were allegedly committed by the grievant. This is paramount. In my considered opinion, a written statement that only included an alleged violation of safety rules and nothing more clearly fails in meeting the criteria set forth by arbitrator Mittenthal. It is simply too broad of a definition that will allow either the union or the grievant to mount any type of a defense or challenge. And in my considered opinion, the due process rights of the grievant were clearly violated in that regard. The emergency placement letter was simply too vague. It failed to clearly identify any specific charge or act that the grievant had committed. Does that sound familiar? Arbitrator Mittenthal calls for the emergency placement letter to define the charge or charges. In this case, there was no specific charge made. Instead, simply a very vanilla type reasoning. And that lack of detail disabled the grievance or the union's ability to formulate any defense in this matter. Even though the grievant union may have received more information at the investigative interview, the employer in this case simply failed in committing any detailed or written documentation in the form of an emergency placement document. I'm going to read that again. Because what you're going to have is them saying, they found out later. They found out at the Formal A what was going on. They weren't hindered. They were able to address it at the Formal A meeting. The Formal A doesn't file the grievance. The shop steward files the grievance. He has an opportunity to investigate, to see if there is a grievance. In this case, I'm not going to help management whatsoever. I'm going to get this, I'm going to write a statement, I'm going to send it to the Formal A. Now they can say, did you request anything? I'm not going to. It's not my burden to prove innocence. It's your burden to prove guilt. You handed me a letter that I can't decipher. I don't have any idea what it was. It's too vague. And so I'm not going to sit here and do your job for you. I'm not going to put the pieces of the puzzle, your puzzle, together. Read that again. Even though the grievant union may have received more information at the investigative interview, the employer in this case simply failed in committing any detail to written documentation in the form of an emergency placement document. Management should have been well aware of the demands of arbitrator Mittenthal. They have been in place for some 20 years. Now, this is back in 2012. Regardless of the discipline or its degree, the notice letter sets the benchmark for each individual case, and this goes along with any discipline whatsoever. When you get a letter of warning that has two provisions on it, right? You go to the Formal A and they've added 10 more. This goes along with that. Regardless of the discipline or its degree, the notice letter sets the benchmark for each individual case. The employer is required to specifically outline in detail each charge which brought rise to the discipline. This provides the union with written notice as well as preventing management an opportunity to alter the charge as the case moves forward. And that goes along with any discipline. You know, when I talked about a long time ago when I did a lot of education, you have the informal step A. You get the letter, charge letter, whatever it is. And it says, Corey Walton violated these provisions of the ELM, and there's 2 provisions. Then you get to the formal step A meeting, and what happened? There's 6 more that I violated. This is what he's talking about. This provides the union with written notice, as well as preventing management an opportunity to alter the charge as the case moves forward. This particular instance involved an alleged vehicle accident. According to the record in this case, the alleged accident occurred on April 28th, 2012. That date of the emergency placement letter was May 14th. Some 2 weeks had expired. And during that time, the employer would have been expected to provide the grievant with a detailed written explanation of the charge that resulted in the emergency placement. Arbitrator Menthal requires the grievant to be formally made aware of the charge against him. The contents of the emergency placement letter in this case simply failed to meet that requisite standard, and he upheld the union's grievance. Here's another one. It's C30322. C30322. This is another one that we did. This is back in August of 2012. We're going to go to page 6. The union steward also testified that he asked the supervisor why he, the supervisor, was putting the grievance out on EP, and the answer he received was, "I do not know." The supervisor testified that he did say, "I do not know," but attempted to explain his answer by saying he was not sure how the EP letter would be worded. It was obvious to me that the supervisor did not investigate the situation and did not really know why he was putting the grievance out on EP. The employer advocate in this case did not have any witnesses to refute the several allegations of the union, which was harmful to management's position. Having reviewed the entire record and the testimony of all the witnesses, I am at a loss myself as to just what it was that the grievant had done that led him to being put out on EP. The letter he received placing him on EP states the action was taken due to your alleged unacceptable conduct, fabrication of records to receive pay while not actually performing work for the United States Postal Service. But does not say anything about what he did or when he did it. The union argued very convincingly that they were not given any specifics of the charges against the grievant. Therefore, it would have been impossible for the union to properly defend the grievant. The union's arguments in this case were substantiated by the record, the testimony of witnesses, and the employer's inability to refute the union's arguments. For those reasons, the union's argument far outweighed those of the employer. The union prevailed on all 3 issues. I'll read that again, this one part. But that does not say anything about what he did or when he did it. The union argued very convincingly that they were not given any specifics of the charges against the grievant. And that's what I did. I handed him the notice. I said, Arbitrator Roberts, can you tell me when this happened? Where it happened? What happened? If you can't, then you have to sustain the grievance. You cannot deny it, because this is what we were handed to defend this gentleman, is this letter here. I can't tell you what happened, when it happened, where it happened, what day it happened. And so those are very compelling arguments when you have something like that, okay? Here's another one. And this is just an FYI. Sorry to bother you. I know you're just coming back. I'm from convention. I wanted to get your thoughts on this. I was told today that I'm not allowed to work for any other delivery service. I do DoorDash on the side. Is that included? No. It's any competition. FedEx, UPS. A lot of carriers are having to subsidize their wages by having outside employment. DoorDashing. I talk about it all the time. You know, this last TA put us in that position. It didn't give us any bump whatsoever. And so a lot of our people, especially single mothers, are having to DoorDash just to provide for their families. And so, no, that is not included. You have to survive, right? You have to put food on the table. And so, yes, that's not included, okay? So it's any competitor. Here's another one. Dear Mr. Walton, my route was walked on August 3rd by a supervisor, and my T6 on my day off, she came to me on August 5th relating to my route, does not need me to write a 3996 daily. My route is out of adjustment. What can I do? And so you put in a 3996 daily in accordance with Article 41, reporting requirements, okay? Anytime you're going to be over on your route, you must submit a 3996. If management tells you not to, request one anyway. If they say, hey, we know it's out of order or out of alignment, out of adjustment, you don't need to keep putting in a 3996. For your protection, I'm telling you now, turn in a 3996 every single day you're going to go into overtime. We do not need them if we're in undertime, like management attempted to do before. They're saying you're going to have undertime, put in a 3996 is for overtime, for auxiliary assistance. Put one in every single day and get a copy. That's going to help us if we have some kind of evaluation, jointly or Section 2 of the M39. If it's a 6-day count, we need those 3996s as proof. They can come back if you have a new postmaster or district manager and they say, hey, if they're not turning in a 3996s, everything is unauthorized. And then what are you going to do? Are you going to expect management to come clean and tell you the truth that they didn't say that? Always protect yourself. Just like in the old days, I used to watch boxing way back when with my dad. And you had a referee, Mills Lane. What'd he say? Protect yourself at all times. He was notorious for that. Protect yourself at all times. That goes with the 3996. If management tells you don't need one, respectfully decline and ask for a 3996, okay? Here's another one. The postmaster states that it should only take 1 minute to deliver a parcel. He says that's contractual. Please advise. Our PM is going on 99s telling carriers that have 30 seconds for each mailbox delivery. He also yells at business owners, employees, if they aren't right at the desk with outgoing mail all ready for pickup. He refuses to do a $39.99 with me. I wish the motherfucker would try that on my route. So you got a postmaster, one telling carriers they get 1 minute per package. Okay? Another one saying you got 30 seconds a mailbox for delivery, and then yelling at business owners. And if anybody's yelling, that's something we're not going to do. We're not going to yell, especially them at us or customers. Get a statement from the customer and file a grievance on Section 115.4 of the M39 handbook, okay? Do that immediately. We're not going to have them. This is a service. It's not a business, okay? So we're going to give good service. We're not going to go out there and yell at our customers. Management damn sure ain't. Okay, so file a Section 115.4 of the M39 handbook on them. Get statements from the customers, the business owners, okay? Also, where they're telling you have 30 seconds for each mailbox delivery, that's a 1769. M1769, that's going to be Article 19 via M1769, okay? And it talks about there is no set pace at which I must walk and no street standard for walking. All right, and there's several others. That one will do, but if you want to put all of them in there, you can, just to kind of, kill a mosquito with a bazooka. But 1769 is all you're going to need. We have no street standard. There is no 30 seconds per delivery. But that's what's going to happen. You see this scanner message saying 2 minutes. Hey, you're sitting too long, 2 minutes. We are the ones under attack right now because Steiner's saying, hey, we're going to cut out overtime. We're going broke. We have to make all these adjustments. The only ones they're making adjustments to are us, right? We're the only ones that they're making adjustments to. We've got to fight this at every level. Nationally, we're going to fight that when we take over the stationary events. We're going to take that to national level arbitration. When you have these things like them saying, hey, you get 30 seconds per stop, that's a grievance under Article 19 via 1769, okay? When it talks about package delivery, 1 minute per package delivery, that's also M1769. Okay? We have no street standard. You're also going to use Section 63 of the M41 Handbook, Delivery of Parcels, 631.1. Determine if someone is available at the address by ringing the doorbell or knocking on the door. Now, I'm supposed to get this package, walk up to the house, knock on the door, and wait. Where does it say that at? The very next thing. 631.2. While waiting for the customer to respond, scan the parcel to verify whether a receipt is required, postage due or other charges are to be collected, a return receipt is requested, delivery is restricted, the carrier release endorsement is used. Put those two things in there we're talking about 1 minute. You're going to beat it with just M1769, but if we go to arbitration, you want to show the arbitrator, here's what we're supposed to do at every box. With every package, we're supposed to walk it up to the door, we're supposed to knock, and while waiting, we're supposed to do that in a minute, and we'll win that easily. But you're going to have more and more of this coming out, as they're trying to restrict us and cut us, right? And so there's two very good things, M1769 and Section 63 of the M41 Handbook, Route Procedures, 631, Delivery of Parcels, okay? And so that's going to help you with that. All right, now lastly, this is one we're going to get irate about, okay? We're going to protect our women on the floor, period. And somebody sent me this. This is going to be a lot of reading, okay? A lot of reading. And it's about a young lady that has to breastfeed, okay? Now this is what it says. I have a coworker that is breastfeeding her child. She is an 8-hour only carrier. The station manager told her that if she's going to take an hour to pump, that she has to stay an hour longer and only get paid for 8. The steward told her there's nothing that they can do. I'll read that again. I have a coworker that is breastfeeding her child. She is an 8-hour only carrier. The station manager told her that if she is going to take an hour to pump, that she has to stay an hour longer and only get paid for 8. So she's going to be working 9 and get paid for 8. Okay? And that's what they're saying. And here's where we're going to go. This is a lot of reading. Okay? You can start off with Article 2. It says at the bottom of 2.1, additionally, in accordance with federal law and regulations, letter carriers have legal recourse to remedy alleged workplace discrimination through the EEOC and the federal courts. Also, Article 5. Article 5 prohibits management taking any unilateral action inconsistent with the terms of the existing agreement or with its obligations under law. Section 8D of the National Labor Relations Act prohibits an employer from making unilateral changes in wages, hours, or working conditions during the term of a collective bargaining agreement. So, with its obligations under law. Now, you can get this directly off the NELC page, and I've got a few other things that you will use, okay? This is a sample letter to give to your employer requesting lactation accommodations. Now, you're going to have to listen to me, okay? You're going to have to listen to all of this. There's a lot of reading here, okay? A sample letter to give your employer requesting lactation accommodations. Ready to request a reasonable modification or adjustment for your lactation-related needs at work? See below for a sample letter you can change to fit your own situation and send to your employer. For more information about your rights to break time and space to pump milk under federal law, visit the Pump for Nursing Mothers Act, What You Should Know. To learn about your right to workplace accommodations while pregnant or postpartum, visit our fact sheet on the Pregnant Workers Fairness Act. A sample letter for asking for pregnancy-related accommodations is available here. Dear so-and-so, I'm writing to share information about the Pump Act and the Pregnant Workers Fairness Act, PWFA. two federal laws that, taken together, require employers to provide employees with reasonable break time and a private, non-bathroom space to pump milk, along with other lactation accommodations. The Pump Act requires employers to provide employees with the following for up to 1 year after childbirth: a private, non-bathroom space to pump milk. This space must be free from intrusion by coworkers and the public. It also must be functional for pumping, including a place for the employee to sit and a flat surface to place the pump. If possible, the employer should also give the employee a way to plug in an electric pump, as well as nearby access to refrigeration and clean running water. Reasonable break time to pump each time the employee needs it. Break frequency and length must be based on the needs of the employee and include time to get to from the pumping station, as well as to set up and clean equipment. Employers may ask hourly employees to clock out during breaks, but may not reduce a salaried employee's salary because they need pumping breaks. For employers who have 50 plus employees, which we are, compliance with the Pump Act is absolutely mandatory. In extremely limited circumstances, employers with fewer than 50 employees, that's not us, are exempt from the requirements. The PWFA requires employers to provide reasonable accommodations for lactation as well as other medical conditions related to pregnancy and childbirth. Covered employees must accommodate their lactating employees unless it would be an undue hardship to do so. They cannot argue that. Lactation accommodations can include but are not limited to break time and a private, non-bathroom space to pump beyond 1 year. Remote work, a flexible schedule, or the ability to directly feed their child. Uniform adjustments. More information about the PWFA is available from the U.S. government. Under both laws, employers must not force an employee to pump on an employer-created schedule, since the timing and duration of pumping breaks should be based on the employee's physical needs. Require an employee to provide medical documentation. I'll read that again. Require an employee to provide medical documentation proving they need to pump, since lactation is a common condition associated with pregnancy, childbirth. Punish or retaliate against an employee for pumping, such as by disciplining them for not meeting metrics they can't meet due to pumping breaks. You may have additional obligations to your pregnant and postpartum workers under other laws. Sincerely. And so that's that. Here's another thing. Information bulletin, and this is the Postal Service bulletin. Postal Service sets policy on accommodating pregnant nursing workers. The Postal Service has issued a policy on providing pregnancy-related accommodations to employees. The Rehabilitation Act of 1973 requires employers to accommodate pregnancy-related medical restrictions if an employee has a qualifying disability. However, under the Pregnant Workers Fairness Act, also known as the PWFA, employers must provide reasonable accommodations to employees with known limitations resulting from pregnancy, childbirth, or related medical conditions, including lactation. Employers must provide reasonable accommodations, whether or not the limitations result in a disability under the Rehabilitation Act, unless accommodations would impose an undue hardship. Also under the PWFA, employers such as the Postal Service must not require a job applicant or employee affected by pregnancy, childbirth, or related medical conditions to accept an accommodation that was not arrived at through an interactive process. Require an employee with pregnancy, childbirth, or related limitations to take leave under any leave law or policy if another reasonable accommodation can be provided that allows the employee to continue working. Deny job opportunities to an applicant or an employee based on the need for reasonable accommodations related to pregnancy, childbirth, or related medical conditions. Employees who need guidance on responding to a request for pregnancy-related accommodations should contact their local reasonable accommodation committee, area employment law office, or district labor relations or human resources office. Employees may also contact the National Disability Program team, whose members are listed on blue. USPS will soon provide hero-based training on reasonable accommodation fundamentals, including pregnancy accommodations. Here's another thing. Workplace accommodations for breastfeeding and lactation. Reasonable accommodations. Now, this is New Jersey, but this will be everywhere. The New Jersey law against discrimination requires employers to make changes to an employee's job or workplace, including break time and space, so that the employee can express milk while at work. Undue hardship. An employer must make these changes unless it can show that making the changes would be extremely difficult or expensive, which they cannot. No arbitrator is going to side with the service on this. Not with a mother, okay? Not with a mother who has to. They all understand. They all have mothers, okay? And they understand the responsibility there to the child and the mother. Retaliations. Employers can't treat an employee differently as a punishment for requesting or using reasonable accommodation. Now, if I'm able to, by law, take breaks as needed to express the milk, you're right? So, by law, I'm able to do that. And you tell me that I'm on 8-hour medical restrictions, but the time you're using to express the milk, we're not going to pay you for that time. Okay? Just know that. We're not going to pay you. If you do it an hour, you're going to work 9 hours and get paid for 8. And I'm going to read part of the law here that they can't do that. But that's retaliation to me. If I'm a mother who just had a child and I choose to breastfeed the child and I have to use a pump or whatever during the day, and I've got some good stuff for you here on the law. And you tell me, I know you've got an 8-hour restriction, but whatever time you're using to do that, I'm not paying you for it. How far are you thinking arbitrators going to go with that? You may not make it through the opening statement. You may not make it. When I'm doing my opening statement, I'm going to tell them exactly what they said. I have a mother here that had a child. Now, if you breastfeed, you understand the pain of that if you don't express the milk. The pain that goes with that, especially a female arbitrator, is going to understand that. But management told me that whatever time I took to do that, they were not going to pay me for it. You're not going to make it past the opening statement. I've had numerous cases where I put on my opening statement and the arbitrator ruled for us right then. They asked management, is that true? Well, yeah. I had a drug case before where they didn't offer him EAP. Is that true? Yes. Well, you're going to offer him EAP and then we'll come back, but everybody's going to get one shot. Those things happen. But anyway, retaliation. Lactation includes manually expressing milk, pumping milk, and breastfeeding, chest feeding, body feeding, or otherwise feeding milk directly from an individual's body to a child. Lactation accommodation requests are time sensitive. Unnecessary delay, inaction, or silence in response to requests for accommodations may violate the LAD. There are no magic words for requesting an accommodation. You don't need to say the words reasonable accommodation or other legal terms to request an accommodation. You can request an accommodation from your boss or human resources representative. An employer cannot seek medical documentation for lactation accommodations. That's law. This means an employer cannot ask for proof that an employee needs a lactation accommodation. Reasonable accommodations. Reasonable break time. An employer may only limit the number of breaks and amount of time an employee uses to express milk if the employer can prove such an accommodation would present an undue hardship which they will never be able to do. And employees may need to express milk during regular paid breaks or during extra breaks at different times. I'll read that again. Employees may need to express milk during regular paid breaks or during extra breaks at different times. A private space, not a bathroom stall, close to where the employee works. A suitable space for milk expression, sometimes referred to as a lactation room, should be clean, well ventilated, and available when it is needed. In most circumstances, it should also include at least the following: appropriate seating, a flat surface other than the floor, an electrical outlet, a nearby sink or a source of running water, a nearby place to store milk like a refrigerator or cooler. Now this is off the NELC site. Workplace issues, pregnancy-related protections, the Pregnancy Workers Fairness Act. The Pregnant Workers Fairness Act, PWFA, requires the Postal Service to provide reasonable accommodations to known limitations related to pregnancy, childbirth, or related medical conditions, unless the accommodation will cause the employer an undue hardship. The EEOC provides a summary of the key provisions of the PWFA. Examples of possible reasonable accommodations include the ability to sit or drink water, receive closer parking, have flexible hours, receive or modify appropriate size uniforms and safety apparel, receive additional break time to use the bathroom, eat, and rest, take leave or time off to recover from childbirth, ability to sit instead of stand, to be excused from strenuous activities, be excused from activities that involve exposure to compounds not safe for pregnancy. Requesting a reasonable accommodation. Identify the limitation, physical or mental condition related to, affected by, or arising out of pregnancy, childbirth, or related medical conditions. Describe the change needed due to the limitation. Additionally, under the PWFA, the Postal Service may not unnecessarily delay making a reasonable accommodation, require an employee to accept an accommodation without a discussion about the accommodation between the worker and the employer, deny a job or other employment opportunities to a qualified employee or applicant based on the person's need for a reasonable accommodation, require an employee to take leave if another reasonable accommodation can be provided that would let the employee keep working, retaliate against an individual for reporting or opposing unlawful discrimination under the PWFA or participating in a PWFA proceeding, such as an investigation, interfere with an individual's rights under the PWFA. For more information, see the EEOC, What You Should Know About Pregnant Workers Fairness Act. The Pregnancy Discrimination Act of 1978. The Pregnancy Discrimination Act of 1978, which amended Title 12 of the Civil Rights Act of 1964, 42 U.S. Code, subsection 2000E, prohibits discrimination on the basis of pregnancy, childbirth, or related medical conditions. Pregnancy discrimination involves treating an individual, an applicant or employee, unfavorably in any aspect of employment, including hiring, firing, pay, job assignments, promotions, layoff, trainings, benefits, such as leave and health insurance, and any other terms and conditions of employment. Family and Medical Leave Act. FMLA protected leave can be used for a new child in the family or for serious health conditions which arise. FMLA guarantees eligible letter carriers up to 12 weeks of leave each postal year. Protections to pump at work. The Pump Act. On December 29th, 2022, the Consolidated Appropriations Act of 2023 became law. This legislation introduced the Pump for Nursing Mothers Act, Pump Act, expanding these rights to more nursing employees, including agriculture workers, nurses, teachers, truck and taxi drivers, home care workers, and managers. The Pump Act is a federal law under the Fair Labor Standards Act, FLSA. the mandates workplace lactation accommodations. The FLSA, as amended by the Pump Act, requires employers to provide covered nursing workers with reasonable break time and a private space other than a bathroom to pump breast milk for 1 year after the baby's birth. The Department of Labor is the federal agency in charge of overseeing the legislation. Frequently asked questions. Under the FLSA as modified by the Pump Act, an employee's ability to use break time to express breast milk is protected. I'll read that again because I messed that up. Under the FLSA as modified by the Pump Act, an employer's ability to use break time to express breast milk is protected. During this time, the employee must be completely relieved from duty or must be paid for the break time. Under the FLSA as modified by the Pump Act, an employee's ability to use break time to express breast milk is protected. During this time, the employee must be completely relieved from duty or must be paid for the break time. So if I'm being told that whatever time I'm expressing my milk, I'm not going to be paid, is a violation of the law. Article 5. Okay? Under the FLSA. If you're saying you're going to work 9 hours but I'm paying you for 8, that's a violation of the law. We have to protect those women. All right? Frequently asked questions. What is covered? Pregnant Workers Fairness Act, PWFA, covers known limitations related to or arising out of pregnancy, childbirth, or related medical conditions, which are generally temporary in nature. Known limitations include physical or mental conditions that are minor, modest, or episodic. Providing urgent maternal protections for Nursing Mothers Act, Pump Act, modifies the existing Fair Labor Standards Act by expanding reasonable break times to express breast milk as needed. What happens when a covered employee needs reasonable accommodation? Upon notification of limitations from a pregnancy-affected employee or their designated representative, postal managers and supervisors are obligated to discuss the accommodation with the employee or their designated representative at the earliest opportunity. This includes determining what the employee is seeking in terms of accommodation, as well as whether or to what extent the requested accommodation or alternative accommodation is reasonable and available under the circumstances. PWFA requires an interactive process. What does that mean? An interactive process is two-way communication between employer and employee or designated representative. It should be initiated upon an employee's or designated representative's request for accommodation. It is an informal exchange, not a one-sided policy. There should not be any unnecessary delays for accommodation, and it should focus on identifying the needs of the employee. What kind of accommodations are available for PWFA requests? Accommodations can include but are not limited to lifting restrictions, minimizing occupational heat, cold stress, reduced standing, walking, more frequent restroom breaks, contagion and or harmful chemical exposure reduction, leave for healthcare appointments, or avoiding exposure to secondhand smoke, to name a few. Does an employee need medical documentation? Medical documentation should not normally be required for obvious common needs. The controlling regulations are very restrictive on what can be requested of the employee. In most cases, where the needs for accommodation is obvious, for example, needing more water or restroom breaks, there should be no request for medical documentation. However, for less obvious or uncommon needs, only limited documentation that is strictly necessary may be requested. What happens when my uniform doesn't fit anymore? The employee or designated representative should open the lines of communication with their supervisor and explain the accommodation needed to aid the supervisor in assisting the request. How do I know if a form is necessary to submit requests for reasonable accommodations in accordance with the PWFA? There is nothing written in the Act which suggests forms are necessary or required for reasonable accommodation requests. I'll read that again. How do I know if a form is necessary to submit requests for reasonable accommodations in accordance with PWFA? There is nothing written in the Act which suggests forms are necessary or required for reasonable accommodation requests. PWFA encourages verbal communication with the employee's immediate supervisor, who has the authority to approve requests. In some cases, the Postal Service may have a legitimate need for certain information when reviewing employees' requests for reasonable accommodations. Scenario: a carrier reports she has a 20-pound lifting restriction due to early stage pregnancy, and her assigned route requires delivering a few packages each day that exceeds 20 pounds. What should happen? Upon notification to the supervisor, local management should provide the employee or designated representative a temporary or interim accommodation while determining operational needs. The employee should not be sent home, and their self-reported medical restrictions should not be ignored. Is my local supervisor going to be able to approve my request for pregnancy-related accommodation? The local supervisor may approve all PWFA accommodation requests except for telework and communication requests. Policy dictates that a supervisor should discuss the request with the next higher level of management if the requested accommodation is not readily available to determine if reasonable accommodation (RAC) referral is needed. What is the meaning of interim reasonable accommodation? This new law anticipates that during the decision-making process, an interim accommodation is provided to the greatest extent possible. The employee should be notified of the delay, and the interim accommodation should be provided if any. That's 29 CFR Part 1663.4. 29 CFR Part 1636. Is my supervisor being advised when a request needs to be referred to the Reasonable Accommodation Committee? An accommodation request goes to the RAC only when local management needs assistance identifying effective and available reasonable accommodations. Management is encouraged to handle many PWFA accommodation requests and to refer the matter to the RAC only when necessary. Postal policy now requires that if local management cannot accommodate pregnancy-related restrictions, then management must immediately refer to the RACs before a pregnant employee is sent home, and that's when RAC comes into play. Can a request for reasonable accommodation be denied under PWFA? Under the PWFA, a request for reasonable accommodation should not be denied unless it creates an undue hardship for the Postal Service. Temporary accommodation is often considered reasonable accommodation. Add link to the PWFA attached. What is the meaning of undue hardship? Under the PWFA, undue hardship generally means the accommodation would cause significant difficulty or expense in light of the operation's circumstances. It requires actual evidence and cannot be based on speculation or minor inconvenience. I'll say that again. Because they're obligated to do a lot of things, right? Provide a lot of things. That's law. So that's not going to be an inconvenience. It's law that you do that. What is the meaning of undue hardship? Under the PWFA, undue hardship generally means the accommodation would cause significant difficulty or expense in light of the operation's circumstances. It requires actual evidence and cannot be based on speculation or minor inconvenience. What can an employee do if the employer refuses to comply with the PWFA? Contact your steward, branch leadership, or your MBA office for further assistance. Who is covered under the Pump Act? Employees covered under the Fair Labor Standards Act, FLSA, are protected. What time does the Postal Service provide for nursing mothers to express milk while on duty? The Postal Service must provide an employee with reasonable break times to express breast milk each time an employee has the need to do so for up to 1 year after birth of the child. Does the break time used for nursing mothers have to be paid? If the employee utilizing their FLSA mandated breaks, the break time must be paid. over their regularly scheduled breaks if the employee is completely relieved from duty. The break time does not have to be paid. I'll read that again. If the employee is utilizing their FLSA mandated breaks, the break time must be paid. Over their regularly scheduled breaks, if the employee is completely relieved from duty, the break time does not have to be paid. Does the Postal Service need to provide a lactation room? The Postal Service must provide a private space that is shielded from view, free from intrusion, and is not a bathroom. So that will not be an inconvenience or a significant difficulty or expense. Okay? Can the Postal Service deny pump breaks because of workload? Workload alone is not a valid reason to deny legally required breaks to pump. I'll read it again. Workload alone is not a valid reason to deny legally required breaks to pump. Here's another thing. I told you it's a lot of reading, didn't I? Fact sheet number 73, FLSA protections for employees to pump breast milk at work. Under the Fair Labor Standards Act, FLSA, most nursing employees have the right to reasonable break time and a place other than a bathroom that is shielded from view to express breast milk while at work. This right is available for up to 1 year after the child's birth. This fact sheet provides general information on the FLSA's protections for nursing employees as extended by the Providing Urgent Maternal Protections for Nursing Mothers Act, PUMP Act, which was signed into law on December 29, 2022. About the FLSA. The FLSA establishes minimum wage, overtime pay, record keeping, and child labor standards affecting the full-time and part-time employees in the private sector and in federal, state, and local governments. The FLSA also protects the rights of employees to pump breast milk at work. Workers may have greater protections under state or local worker protection laws. The FLSA does not preempt state or local laws that provide greater protections to employees. Break time to pump breast milk. Most employees have the right to take reasonable break time to express breast milk for their nursing child. For 1 year after the child's birth, covered employees may take reasonable break time. Each time such employee has to express milk, an employer may not deny a covered employee a needed break to pump. The frequency and duration of breaks needed to express milk will likely vary depending on factors relating to the nursing employee and the child. Factors such as the location of the space and the steps reasonably necessary to express milk, such as pump setup, can also affect the duration of time an employee will need to express milk. Employees who telework are eligible to take pump breaks under the FLSA on the same basis as other employees. Private space to pump breast milk. Covered employees must be provided with a place, other than a bathroom, that is shielded from view and free from intrusion from coworkers and the public, which may be used by an employee to express breast milk. Under the FLSA, a bathroom, even if private, is not a permissible location for the employer to provide for pumping breast milk. The location provided must be functional as a space for expressing breast milk. If the space is not dedicated to the nursing employee's use, it must be available when needed by the employee in order to meet the statutory requirement. A space temporarily created or converted into a space for expressing breast milk or made available when needed by the nursing employee is sufficient, provided that the space is shielded from view and free from any intrusion from coworkers and the public. Workers who telework must be also free from observation by an employer providing a required video system, including computer camera, security camera, or web conferencing platform. Covered employees. As of December 29, 2022, nearly all FLSA covered employees have the right to take needed time and to access an appropriate space to express breast milk for a nursing child for up to 1 year after the child's birth. For more information about FLSA coverage, see fact sheet number 14. Examples: Julia cleans guest rooms at hotels on weekends. Julia is entitled to break time and space under the FLSA for 1 year after the birth of a child. Samantha is a registered nurse who is exempt from receiving overtime pay under the FLSA. Beginning on December 29, 2022, Samantha is entitled to break time and space for 1 year after the birth of a child. Irina is the shift manager at a fast food restaurant with several locations and meets all requirements to be exempt from overtime pay requirements under the FLSA. When Irina returns to work after the birth of her child in March 2023, in order to comply with the law, her employer provides an office to take 4 breaks a day of 25 minutes each to pump breast milk for the nursing child. Compensation for break time to pump breast milk. Under the FLSA, when an employee is using break time at work to express breast milk, they either must be completely relieved from duty or must be paid for the break time. And that's what we're talking about here with this asshole manager. Further, when employers provide paid breaks, an employee who uses such break time to pump breast milk must be compensated in the same way that other employees are compensated for break time. For more information about that, must be compensated, see fact sheet number 22, 2020, fact sheet 22. Examples: Madison works on a farm. Madison's employer provides all employees with 2 15-minute breaks each day. Madison chooses to use both of those paid 15-minute breaks to pump breast milk for her 6-month-old infant. If Madison needs additional breaks to pump, the additional break time does not have to be compensated as long as Madison does not perform any work during the breaks. Peyton is a 3rd grade teacher. Under the FLSA, Peyton is entitled to time to pump breast milk in a private space. Peyton chooses to grade papers and complete student records while pumping breast milk. Peyton must be compensated for the time spent pumping and doing this work at the same time. Lauren's employer requires all employees to attend a team building and meeting at 3 p.m. on Thursday. Lauren requests break time to pump during the Thursday meeting. Lauren's employer denies her request in violation of the FLSA. Lauren must be paid for the time attending the meeting and must be permitted time and space to pump. It is a violation of the FLSA for any person to discharge or in any other manner discriminate against any employee because such employee has filed any complaint or instituted or caused to be instituted any proceeding under the related to this act, or has testified or is about to testify in any such proceedings, or has served or is about to serve in any industry committee. Moving on. We're still going. Got 2 more. FLSA protections to pump at work. Coverage for certain employees of rail carriers and motor coach services operators begins December 29, 2025. The Fair Labor Standards Act, FLSA, requires employers to provide reasonable break time for an employee to express breast milk for her nursing child for 1 year after the child's birth, each time such employee has needs to express the milk. Employees are entitled to a place to pump at work other than a bathroom that is shielded from view and free from intrusion from co-workers and the public. What you should know: under the Fair Labor Standards Act, FLSA, most nursing workers are entitled to reasonable break time and a private space to pump at work for up to 1 year after their child's birth. Most employers are required to provide covered employees with space that is functional for pumping milk, shielded from view, free from intrusion, available as needed, and not a bathroom. New law expanding pump at work protections. On December 29, 2022, the Consolidated Appropriations Act of 2023 became law. This legislation introduced the Pump for Nursing Mothers Act, PUMP Act, expanding these rights to more nursing employees, including agriculture workers, nurses, teachers, truck drivers, and taxi drivers, home care workers, and managers. All right, here's the last thing. Frequently asked questions pumping breast milk at work about the law. On December 29, 2022, President Biden signed the Consolidated Appropriations Act of 2023 into law. The law includes the Pump for Nursing Mothers Act, PUMP Act, which extends to more nursing employees the rights to receive break time to pump and a private place to pump at work, and may impact some of the other information provided below. Under the Pump Act, most nursing employees have the right to reasonable break time and a place other than a bathroom that is shielded from view and free from intrusion to express breast milk while at work. This right is available for up to 1 year after the child's birth. Questions and answers. How do I know if federal pump at work requirements apply to me and if I have a right to take pump breaks at work? Under the Fair Labor Standards Act, most employees have the right to reasonable break time and a private place to pump breast milk for her nursing child. Specifically, covered employees are required to provide reasonable break time for an employee to express breast milk for her nursing child each time such employee has need to express the milk for 1 year after the child's birth. For more information about FLSA coverage, see Fact Sheet 14. Employees are entitled to a place to pump at work other than a bathroom that is shielded from view and free from intrusion from coworkers and the public. Certain employees of airlines, railroads, and motor coach carriers are exempt from the pump at work protections of the FLSA. Employees who are exempted may be entitled to break time and or space protections under the other laws. For more information about federal and state level employee protections, see the U.S. Department of Labor's Women's Bureau information page, Employment Issues Related to Pregnancy, Birth, and Nursing. What must an employer provide to workers who need to express breast milk in the workplace? Employers are required to provide a reasonable amount of break time and a space to express milk as frequently as needed by the nursing employee for up to 1 year following the birth of the employee's child. The frequency of breaks needed to express breast milk as well as the duration of each break will likely vary. The space provided by the employer cannot be a bathroom, and it must be shielded from view and free from intrusion by coworkers or the public. Does the break time have to be paid break time? If an employee is not completely relieved from duty, time used to pump breast milk at work must be paid. For more information on what it means to be completely relieved from duty, see Wage and Hour Division Fact Sheet 22, Hours Worked under the FLSA. If employers provide paid breaks, an employee who expresses milk during a break must be compensated in the same way that other employees are compensated for break time. Additionally, employees must be paid for breaks as required by state or local laws that apply to them. Take breaks as needed in the heat. Do we get paid for those additional breaks? Yes, we do. Right? We get 2 10-minute breaks, but then during the summer, when it gets real hot, both parties tell us to take breaks as needed in the heat. Well, we do. They don't. But you're supposed to take breaks as needed in the heat, and that would be my contention. During the summer, we're told to take breaks as needed in the heat. We're paid for those breaks. We file grievances if management puts us in the 1017A log to not pay us for those breaks, and we will win that because you must pay me for the breaks taken at work. This is no different. Do employers need to create a permanent, dedicated space for use by nursing employees? An employer may create or convert a temporary space for expressing milk or make a space available when needed. The space must be shielded from view and free from any intrusion from coworkers and the public. The location provided must be functional as a space for expressing breast milk. If the space is not dedicated to the nursing employee's use, it must be available when the employee needs it in order to meet the statutory requirement. Employers may also choose to create permanent, dedicated spaces for employees to express breast milk. Do employers have to provide a space to pump breast milk even if they don't have any nursing employees? The statute requires employers to provide a space for a nursing employee each time such employee has need to express the milk. If there is no employee with a need to express breast milk, then the employer would not have an obligation to provide a space. It is a best practice for employers to consider where they will make a space available when it is needed. If the only space available to express breast milk at work site is a bathroom, can employers require employees to express breast milk there? No. The statute specifically states that the space provided for employees to express breast milk cannot be a bathroom. Can an employer require an employee to submit a doctor's note before allowing an employee to take pump breaks? No. An employer may not require an employee to provide a doctor's note before allowing an employee to take pump breaks. The FLSA requires employers to provide reasonable break time for an employee to express breast milk for her nursing child for 1 year after the child's birth each time the employee has need to express the milk. Employees are entitled to a place to pump at work, other than a bathroom that is shielded from view and free from intrusion from co-workers and the public. What should I do if I'm denied space or break time to pump? If you think your right to reasonable break time in a space that is shielded from view and free from intrusion to pump at work has been violated, you may file a complaint with the Wage and Hour Division or file a private cause of action seeking appropriate remedies. You can call or visit any Wage and Hour office to ask questions or file a complaint. You can also call our toll-free helpline, 1-866-487-9243. 1-866-487-9243. If you choose to file a private action for your employer's failure to provide an appropriate space to pump, you may be required to provide your employer notice of the failure and 10 days to come into compliance. You are not required to provide notice, however, before filing a complaint with the Wage and Hour Division or when filing a private action for your employer's failure to provide reasonable break time. An employer cannot retaliate against you for exercising your rights, filing a complaint, or cooperating with an investigation. What might I be able to recover if my right to pump at work was violated? If your right to pump at work was violated, you may be entitled to remedies that are available under the FLSA, such as employment reinstatement, promotion, payment of lost wages, and an equal amount as liquidated damages, compensatory damages, and make whole relief. Now, we would file a grievance and say that they be compensated for that hour, right? If you say I need to pump, and if I got 8-hour medical restriction, I'm not going past 8 hours. If they say, hey, if you're going to pump for an hour, you're going to work 9. I have a working restriction. I can't work past 8 hours. And so, we'll go to bat for that as well, okay? Protect your women. Protect your women. You have managers out there that do not care. It's about numbers. They will kill us in the yard. They will kill us stone dead in somebody's yard. You think they care about our women having to breastfeed, having to express that milk? No. I had a grievance way back when I was a former lady. This is way back in 2009. And we wanted the DRT where a pregnant woman came in. They sent her home. We ain't got no work for you. Well, I can work. We don't have any work for you. You're pregnant. Now, that was legitimately what they said. She didn't ask for anything different. She didn't ask for any accommodations. She didn't have any restrictions. We can't work you. You're pregnant. That's foolish. But that's how they are. That's how they feel about us, okay? And that's why I keep saying when we get in there, we will be retribution. Retribution is coming, okay? We will be retribution to these people that have done this to us for so long. That is coming once we take over, okay? We'll be attacking the workroom floor like never before in the history of the NALC. The workroom floor will be buzzing with us, okay? And that's a promise from me to you. We're going to educate the workroom floor. That's happening, okay? Get excited about that. And so there you have it. There's your episode, Salted Peanuts. That's going to be every Monday. Going to do that, okay? Trying to stay away from politics on that. Just get back to the roots of educating. And that's good. That's a good thing. Next Sunday, okay, we'll have more members of the CLC slate. The Table 2 carriers will be on. There's 3 of them on the slate, and they'll be on Sunday. Make sure you listen to that. And then next Monday, I've already got a lot of stuff I'm going to cover next Monday, back to educating, okay? Hey, I love you, Light Blue. I love you with everything in me. Even if you hate me, I love you. I got you, okay? Even if you talk about me, I got you. I'm going to fight for you, okay? Because that's what we do. I'm going to fight for you. I love you. Y'all have a fantastic week. Please be safe. Still hot out there. We're not out of the danger zone yet. All right? And I'll talk to y'all Sunday. Bye.